All right. Well, good morning or good afternoon, everyone. My name is Matt Perlow, and I'm a partner in Husch Blackwell's Financial Services and Capital Markets Group. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit your question via the question box. I may try to answer questions during the webcast today, but if I can't get to you or a fuller answer is needed, I will try to answer you later by email. A PDF of the presentation is available in the resources folder. This program has been approved for legal education hours, so to report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. So that's all for the housekeeping items. Let's go ahead and get started with the program. So I've had the good fortune to practice in the area of nonprofit organizations for about 35 years. And those of you who are involved with nonprofits know how important the mission is. It's the center of everything. It's why you're there. But what we're going to talk about today is that aspect of charitable organizations which sometimes gets glossed over, governance. Nonprofit organizations don't exist for the purpose of their governance, but their governance is essential for their existence. It's what makes the mission possible, and ignoring it imperils the mission. So today we will have an in-depth talk about the governance for nonprofits. This webinar will cover organizational structure, sources of governance authority, including best practices and suggested policies, as well as additional topics. I hope you'll walk away with practical information you can use to steer your organization towards a sustainable future. So what is governance? Kind of a simple answer is that it's the exercise of authority and control over an organization. A classic organizational structure is kind of the following hierarchy. We start with members, and then below members, the board, and then officers and committees, and then staff. And of course, not every organization is set up quite this way, but it's a good place to start. And so I want to ask everybody initially is how many of you are associated with organizations which have members? If you go ahead and answer that question. Okay, this is interesting. So we've got 66% or 2/3 saying that they're organizations with members. Now, it could be that we're talking about different types of members, and let me go ahead and explain that. So we're not really talking about with respect to governance in kind of your average member, of a zoo perhaps, who gets free train rides in exchange for a $30 annual membership. What we're really referring to here are individuals or entities who have the right to vote on specific matters. And to give you a little history, in my state, nonprofit organizations were originally set up by courts on the basis of a petition by individuals who generally became then the members of the corporation. I think typically membership corporations are a little less common, but something that we do need to talk about, and in our case here with the people attending, may be a more common than I actually anticipated. So again, the members are those individuals or entities, because they're not always people, who have the right to vote or direct things on specific matters. And generally, only specific major matters, and they can include, the right to elect directors, the right to approve fundamental transactions, such as terminating the organization, selling all or substantially all the assets, amending the bylaws and articles. The members generally have no direct role in management or authority, and generally only meet once a year if there are meetings. I see this used sometimes by religious-related organizations where there's a sponsoring religious institution as the member, and they retain powers effectively to ensure that the organization doesn't stray from the charism or mission of the sponsor, but can also be used in other circumstances where that desire to retain control over the direction is a reason for the members to exist. So moving on to the board and down the hierarchy, the board is where primary legal authority resides. The board is supposed to guide the organization and not be a rubber stamp, for the officers or the executive director. They're to oversee the actions of the officers and, to a lesser extent, the staff. And if there is a member, report to the members, if any, regarding the affairs and activities of the organization. Next level of governance is comprised of the officers and committees of the board, who generally have the authority or the role of implementing policies and programs established by the board and exercising authority as delegated by the board. Though I wonder how many people have seen organizations where the officers and staff effectively run the organization and the board just approves what they do. I didn't make that a poll question, though maybe it should have been. The officers and committees can help make day-to-day decisions regarding the operation of the organization and then report to the board regarding the affairs and activities of the organization. And finally, the staff, which is where the mission is generally really accomplished. They carry out the purposes and activities of the organization and then report to the officers and board regarding the activities and affairs. So you see with the hierarchy, the authority kind of flowing down and then the reports going back up. The staff isn't supposed to be doing their duties in a vacuum or go off on their own, but again, with the guidance that comes from the board and the officers. So what are the sources of the governance authority that is being exercised by the various individuals? And here, where do you look for the rules? The rules are generally contained in three places. First in the articles, which is generally the foundational document. It's the constitution of the organization, as it were. Then there are the many basic rules in the bylaws. How many directors, how are they and officers chosen and elected, how are meetings held, and what are the rules regarding the meetings, quorum, number of meetings, etc. Finally, state and federal law dictate some of the content of the articles and bylaws, but also cover other subjects and establish other rules. In addition to the kind of legal rules, there are so-called best practices that can rise to the level of almost de facto rules. There's a couple of subjects or a couple of sources here that I'm pointing out. One is the IRS has a publication that's entitled Governance and Related Topics, in which it states its opinion on what organizations should do. The introductory sentence of the article, in effect, saying that the IRS believes that a well-governed organization is more likely to follow the tax laws. Another place you can find these best practices are with the Wise Giving Alliance, part of the Better Business Bureau, which publishes suggested practices. To look at the IRS governance suggestions, they cover a number of subjects. The mission statement, which encourages organizations to establish and review a mission statement regularly. With respect to organizational documents, they point generally to state law as governing. The IRS encourages an active and engaged board, and we'll talk more about this later. The IRS does not require governance and management policies, but indicates that these are important to ensure that the IRS rules are being followed. The IRS encourages a board to regularly review and receive financial statements, including tax returns, which we'll talk about again in a bit. And the IRS emphasizes that transparency for an organization provides for accountability to constituents. These IRS suggestions are important, at all levels, but also, remember that they have a tendency sometimes to move towards de facto, if not de jure requirements. Ten basic board responsibilities. BoardSource, which is an independent organization, has published its list of 10 suggested basic board responsibilities. Not everything the board is going to be doing, but 10 things that the boards should be focusing on. Determine the mission, vision, and values. Understand the board and staff relationship, the right balance between being a rubber stamp and being a micromanaging board. Choose, support, and evaluate the chief executive, and we'll talk a lot more about that later. Ensure effective fiscal management and raise money, the lifeblood of many organizations. Engage in program and performance assessment, both the performance of the organization, and the board. Engage in strategic planning, because it's not a good idea to just let things happen or go on the way they always have. Enhance the public standing of the organization. Board members need to be good ambassadors of the organization. And select new board members. The board needs to perpetuate itself unless there's another method of choosing the board by, for example, the members. And then to organize, to operate efficiently. Use the resources or the organization well in order to maximize the mission. Now, all of these best practices and IRS suggestions are really, in essence, an outgrowth of the basic legal duties of officers and directors. The primary one, or the primary legal duty of which, is that a board member or officer has the duty of care. The duty to act in good faith with the care of an ordinarily prudent person in a manner the director believes to be in the best interest of the corporation. And let's kind of parse that out here. The duty to act in good faith. This is a duty to act not negligently, with the focus on the organization, with the care of an ordinarily prudent person. So it's ordinarily prudent. They don't have to be the best or the smartest, just an ordinarily prudent person. Prudent, not a careless individual, in a manner that the director believes. So belief is what's important here. They can be wrong. They don't have to always be right, but they have to believe that they're doing the right thing and in the best interest of the corporation, not in their own interest. So we'll go through some situations later and see how the duties that we're going to talk about are implicated. The second primary duty is the duty of loyalty. The director must act in the best interest of the corporation. And as you can see, this overlaps, with the duty of care. And not in the interest of another person or entity. Lots of different examples of that, again, which we'll talk about. But just wanted to throw out, what if an individual is on two boards that deal with kind of similar subjects? Is there going to be a conflict of interest there? Or is it affecting their duty of loyalty? And the board member or officer must maintain confidentiality. They need to be a supporter of their organization, but they shouldn't share sensitive information. A third duty that many people think is a part of the duty of loyalty is the duty of obedience. And I just saw that somebody asked, will these slides be available? And it's my understanding that you will receive a PDF copy of these slides after the presentation. So you will get a copy of those. So the duty of obedience. A director must ensure that the organization conforms or remains obedient to its purposes. And an example of this is a situation that I saw in a case where a hospital was not allowed to close by a court and open up a clinic instead. The court said that the board had a duty to continue the organization's purpose and cited the fact that the community needed the hospital. So what if a board member or officer violates these duties? What type of liability might exist? There can be actions for breach of contract, tort, personal injury. There can be tax liabilities. How can a board or officer protect themselves? One level of protection are volunteer protection statutes. There is a Federal Volunteer Protection Act which protects directors from punitive damages unless they are willful acts. States have volunteer protection acts which protect volunteers, those receiving no compensation, no remuneration for what they're doing, if actions are not intentional or malicious or negligent. But probably one of the better sources of protection for individuals, if the organization can afford it, is indemnification. And the indemnification can be funded with insurance, directors and officers insurance, for example. And in that situation, it would be typically authorized in the bylaws of the organization. Now to one of those situations I've mentioned. We've had the same mission for 40 years. Everyone knows what we do. Is this a problem? Does this violate any of the duties that I mentioned? Well, perhaps. Does it violate the duty of care? There's a need to reconsider the mission from time to time. What if it is obsolete or is becoming obsolete? What should the organization do? A classic example of this is the March of Dimes, which pivoted from dealing with polio, which was effectively eradicated, to the health of mothers and babies. So again, reconsideration of the mission is important. And let's talk about the mission. So the mission, again, the IRS thinks everyone needs one. It's a roadmap for the board. It has both internal and external purposes. It serves externally to explain and popularize the purpose, and internally, to guide the work of the organization. It should include why the organization exists. What are its goals? What's it going to be doing? What are the activities that the organization is going to undertake? What is it going to do? So best practices say that an organization should have a mission statement, which should be approved by the board of directors and reviewed regularly. Again, best practices say at least every 2 years. The board is responsible for monitoring this mission, including if there are local affiliates, to make sure that there's not mission drift, especially where you've got a large organization with a number of affiliates. That can happen over time. Now, the good news is that 99% of nonprofit organizations have a mission statement. I guess the question is how many of these mission statements are reviewed regularly? Another situation to consider, our board has 30 members, but only about 1/3 of them attend any particular meeting. Is there any problem here? I think it violates the duty of care for those individuals who are not attending if they don't have a good reason, and maybe the rest of the board too, if they're not doing anything about it. Well, but our quorum is 1/4 of the total number of the board members, so we don't have a problem, right? Well, perhaps not legally as to the effectiveness of board actions, but the board is losing the opinions, the experiences of those other individuals. There could be some actions requiring a supermajority, but even so, if not, again, the board is probably losing its effectiveness. So how do you deal with this issue? Should there be automatic removal of board members? Maybe, but possibly there is another reason for the person being on the board. And we've probably all seen this, where you have a board member who is an incredible fundraiser, they have a particular skill that's important. So an alternative may be to the automatic removal is just automatic removal with the board being allowed to grant exceptions. Or as an alternative, maybe there's some other position or advisory board, that an individual can serve on instead. So in connection with considering the board, the question is often, how big should a board be? Best practices say large enough to serve the needs of the organization, which obviously is not a whole lot of guidance. The IRS doesn't specify. They don't really suggest any particular number. Missouri law says at least 3 members, and I think this is a fairly common number that you see among states. And the Better Business Bureau says at least 5 voting members. Now, people who are involved with new organizations probably have the experience that often these new organizations, they start off small and then expand their board as their needs change and the organization goes on and attracts new interest and new members. So there's a lot written about optimal board size. What if the board is too small? There are suggestions that if the board is too small, there's insufficient community representation, which some advisors say is important, including the IRS. There may be too few skills and too few resources to accomplish the mission of the organization. Can a small board do everything that is needed for the organization? What if the board is too large? Decision-making might get delayed. too many cooks in the kitchen, not able to reach decisions, or too difficult potentially to get a quorum. There can be too much delegation. You may get the, someone else will do it sort of syndrome that comes up. And there could be lack of oversight because of lack of involvement of some of these board members because of it being so large. Yet the interesting thing is that studies have indicated that boards that are large don't seem to be a problem for organizational effectiveness. It may be because the board is acting in a different way through an executive committee, perhaps. Good practice says that right-sized boards further the charitable purpose of the organization, monitor the activity of the organization to ensure the mission is met, and then finally provide oversight without meddling. It's achieving that balance that we've mentioned, not being a rubber stamp and not micromanaging. There was a question asked, what if the board or some members have issue with part of an organization's mission and wants to change it when the staff does not want it to change? That's an interesting question, and I'm not sure there's an absolute answer to that. I think that it's a matter of discussion and what are the reasons behind it. Obviously, it's the board's responsibility to provide the direction to the organization. Now, dealing with board size, national studies find that the average board size is 16 members. And obviously, that's going to be affected a lot by the numbers on both ends. Studies indicate that large board size doesn't weaken performance, and that 70% of boards have trouble recruiting. I would think, especially in these days with COVID and things not being as active, that's becoming a greater difficulty. So what about boards that don't recruit new members? Our 6 board members have served well for years. Why do we need to change? Is this okay? Doesn't it violate the duty of care? Maybe. Do the individuals really have the interest of the organization in mind? Does it violate the duty of loyalty? Are these 6 individuals loyal to each other? Or, where will new ideas come from? Now, it's possible that everything is working fine, but is it? Without new voices, without new members on the board, how are you going to evaluate that the organization really is doing what it should be doing and the board is operating in the way it should be operating? So a governing body should be, according to best practices, independent representatives of the community, active and involved, and knowledgeable. And let's talk about some of those. So what is independent? The IRS has defined independence in its pronouncements, indicating that board members who are employees or who receive more than $10,000 in payments are not independent. Board members who are related to key employees are not independent. And board members should not have business or family relationships. And that last requirement, I think, can be, problematic in that, how do boards recruit? People generally recruit from their circles. And oftentimes, that's individual with, if not family relationships, business relationships. Excuse me, I skipped one, I think. Considers the suggestion that the board be representative of the community. So the board represents the community in that essentially under the law, the community owns a charity. The assets of a nonprofit are dedicated to the well-being of the citizens of the state in which it's located. In most states, the Attorney General stands in for that community and has standing in any court actions affecting, or with respect to, I should say, the organization. The suggestion that a board be active and involved, implicates that duty of care again. Board members need to attend the meetings. We talked about that before. If they're not attending the meeting, it can be a problem with the board not being effective by not having the individual's views. They need to attend events, go to the gala, go to the car wash, support the organization. Participate in board discussions, not just sit there, provide that opinion, provide that insight, including registering disagreements and having them recorded in the bylaws. Wonder how often, that this is done. And understand and support the organization's mission. Give the money, be an ambassador, have your elevator speech. So board members need to be knowledgeable. They need to know about the mission and the activities of the organization. The board also needs members with different skills. Legal, perhaps, accounting, program-related, and fundraising. Also, potentially public relations, human resources, tech. It really depends on the needs of the organization. And, a skills matrix can be helpful. It can be something that can be used by the organization. And just curious how many organizations with which you are involved use a skills matrix in connection with board recruiting. I just want to mention that a question was raised about board officers and committees making day-to-day decisions, and and that should be the management's role. I think there's an interplay there, and I do understand that oftentimes the more the day-to-day is with the management, but officers can, and depending upon the organization, have some of that role. Question was also asked about focusing on diversity, which I'm going to mention here in a second, and then registering disagreements. They need to be recorded in the minutes. If I said bylaws, I meant to say minutes. Okay. So do organizations with which you're involved use a skills matrix? We've got a 47% yes and a 53% no. What I've found is that the skills matrix can be helpful. You can look at it and see which board members are rotating on or off if you've got a staggered board. And then it can also be used to promote diversity, which is an extremely important role, or extremely important goal of organizations now. And it's a way of keeping track for the organization. So you have a board member or a board with the right number and the right skills. How often should the board meet? A minimum of 3 times a year is what the Better Business Bureau says, with the majority in attendance. The average board meets 7 times a year and meets for 16.5 hours annually. So, this is one of the questions that was raised, is how long should board meetings be? There's really no, I guess, absolute number that you can point to. If the average board meets 7 times a year and meets for an average of 16.5 hours, that's somewhere over 2 hours and perhaps under 3. That's what I've seen in my experiences as being kind of average board meetings. So let's consider another scenario. Our secretary has missed the past 4 quarterly board meetings. We don't have any minutes for at least those 4 meetings. In fact, we can't locate minutes for several other meetings, and no one keeps the minutes for any committees. So what's the issue here? You know, this is a violation of that duty of care and the duty of loyalty. Perhaps if the secretary is busy with other things. Without someone doing the minutes, how do you prove actions were appropriately taken or conflicts considered? Minutes protect the organization, the board, and its officers. So board minutes should document the actions of the board. They also inform members who are unable to attend. You know, that's an important aspect of them. And again, they enable members to register dissent. Question was raised about, you know, if minutes are discoverable, you know, how detailed should they be? And I guess that's something, you know, that every organization has to consider in the context of preparing the minutes. Another question. Our bylaws were revised in 1994 and have worked well for us since. Is that something that we should do? Is there a problem here? I think this raises the question of, are the bylaws really being followed? Are actions really appropriately authorized? Laws may have changed in the interim if those bylaws haven't been looked at. If, you know, they've been in existence since 1994, but they're still working and they've been regularly reviewed, maybe they're fine. But are they? And again, this is one of the aspects of the duty of care that should be followed. Similarly, we don't have any written corporate policies. So we're going to spend a little time on corporate policies. What I found is many organizations don't have them, but the IRS, the Better Business Bureau, and others are pushing organizations to adopt them. Now, this is a list of some basic recommended corporate policies, starting out with the conflict of interest policy being almost number 1. The IRS really pushes this. Not legally required, but the IRS asks about it and may see the absence of a conflict of interest policy as an indication that the organization is not being run for public purposes. Code of ethics sometimes exists. A whistleblower policy can be extremely important. Document retention and destruction policy. Executive compensation policy and procedures and fundraising. And we'll talk about most of these and situations that implicate them over the next 20 minutes. Starting with, our executive director hired her daughter to recruit new members. The daughter's salary is almost twice the previous employee's salary. The executive director supervises and reviews her daughter, but the president of the board approved the hiring. So what questions does this raise? The daughter's getting twice the previous employee's salary. Is she worth it? She could be. Maybe there was research done to show that the comparative salaries being paid or salaries being paid to individuals in comparative situations are really twice what the previous employee was receiving. The executive director supervises and reviews her daughter. It appears that there's a conflict here, and that is something that the organization needs to consider carefully. And the president of the board approved the hiring. But did the board do it in accordance with its bylaws and any conflict policy? Violating conflicts of interest policies can not only be bad policy, but could result in tax liability under the excess benefit rules of the Internal Revenue Code, which we'll talk about here in a bit. Another question, another situation. One director's accounting firm does all of our accounting work and charges us for it. Okay. She says she assigns the work to new accountants with a lower billing rate to save us money. Raises a lot of questions. Do the accountants with the lower billing rate have the right expertise? Is the organization getting value? Remember, conflicts of interest don't have to mean that what is happening is wrong if the organization is not hurt and in fact benefits from the transaction. But conflict of interest policies are meant to ensure that the organization is receiving value and there's not undue benefit to individuals who are in the organization or related to them. So conflict of interest policies. They implicate the duty of loyalty. They ought to be affirmed annually. Applies to board members and officers, employees, including an executive director. They should define what a conflict of interest is so that individuals who are dealing with situations know what they should be looking for. There should be a method of notification and then therefore possible approval or disapproval. And the good news is 47% of nonprofits do have a conflict of interest policy. Now, a question for you guys. Do organizations with which you are involved affirm their conflict policy annually? And if you'd answer yes or no. Okay, so those are pretty good numbers. 76.8% says yes, only 23.2% say no. This is an important part of having the conflict of interest policy is making sure that board members, officers, et cetera, are aware of it and keep it foremost in their mind in carrying out their activities in connection with the organization. So it's something that everybody ought to consider, and the governance committee of the organization probably needs to make sure that that's done if there is one. Moving on from conflicts of interest, another scenario involving policies is where an employee has complained that we are misrepresenting grant expenses. She's always been a troublemaker. We should just fire her. Now, this situation obviously would violate a whistleblower policy. Whistleblower policies, are extremely important because it can be a federal or state offense to retaliate against a whistleblower. The policy should define what a whistleblower is, provide a method for reporting improprieties, obviously not to the person accused. If there is a person designated and that designated person happens to be the accused, then the policy ought to provide for an alternative designated individual to report the impropriety. They should establish guidelines for treatment of those reporting, obviously some confidentiality and protection from being terminated. And in order for them to be effective, they need to be communicated to all employees. On to another policy. Say you have an organization which provides services and it's reported that some clients have threatened to sue the organization for malpractice. Our minutes used to show the board debates about service quality that were later resolved. We got rid of those minutes. Now, this would violate a document retention policy if the organization has one, and could cause problems if there is litigation or an investigation. So document retention and destruction policies. For those of you who know about Sarbanes-Oxley, it makes this applicable to nonprofits in that it is a crime under Sarbanes-Oxley to destroy documents in certain situations. These policies set the time limit for document retention, but allow historically important documents to be retained, so not all documents are to be destroyed. The policy should prohibit destruction of documents when litigation is occurring or anticipated. All right, and then on to another policy. We haven't formally reviewed our executive director for 3 years. The board wants him to stay. We just give him regular raises and pay for his car, I think. Well, the question is, does the board know exactly what the executive director does? All of this may be okay, but again, the duty of care and loyalty is implicated. Is the board in the executive director's pocket? Board and staff review is important. Clear job descriptions should be developed by the board, probably in consultation with the officers if we're dealing with officers. The Wise Giving Alliance recommends review of chief executive at least every 2 years, and personnel reviews should be documented in writing. So why have a compensation and review policy? Well, it's good, first and foremost, for effective operations. It also helps guard against the intermediate sanctions that can be imposed by the IRS. And intermediate sanctions are potential tax liabilities for the officers and then also for the organization. Under these rules, if compensation is set by an independent board, the decision is contemporaneously documented, and in making that decision, comparative statistics are used. It establishes a presumption of reasonableness with the IRS, which can help avoid taxes that could be imposed on the officer or the organization. Let's turn to fundraising. Now, we've heard that telephone solicitors raise a lot of money. Should we consider hiring a phone solicitor? Nothing intrinsically wrong with phone solicitors, but it's a hot button issue with the IRS. You know, is there enough value going to the charity? You know, is there, 90% going to the solicitor, 10% to the charity? That's something that raises the IRS's eyebrows. How about if one of our donors gave us some land that used to be a gas station? He said it was worth $200,000. How could we turn it down? Now, there's obviously potential environmental issues here with the gas station. Yet it can be hard to turn some donors down. What if this donor gives you a lot? How do you refuse this person in those situations? So fundraising policy can help avoid issues like those raised in the previous slides. A good policy provides information to the public on fundraising practices and results, and thereby is a fundraising tool. The organization needs to monitor its policies to ensure ongoing compliance with state laws. Excuse me. And the policy can define acceptable types of fundraising, which can allow the organization to address issues like telephone fundraising if that's not something the organization wants to do. It can also establish a gift acceptance policy. Gift acceptance policies can actually give your individuals or your people involved with the organization doing fundraising a shield when they're offered, say, something by a donor and they have to refuse. Some additional recommended policies include expense reimbursement, investment, travel, gift acceptance, as we mentioned, and affiliate activity, how to control, these related organizations. So what if a director says, I don't always understand the budget or the results. We just let the treasurer take care of that. Now, obviously, not every director may be financially savvy, but they should have a basic understanding. It's part of their duty of care. So with respect to financial reporting, the board should be apprised of the financial condition regularly. How often should this be done? Monthly? Quarterly? Depending upon, I guess, the situation of the board and what is going on with the organization. This is where having a good finance committee and perhaps chair of that finance committee is crucial to help guide the board through some of the financial issues. The board should set and approve an annual budget. And larger organizations should consider an independent audit, which is actually required in certain situations by states or fundraisers, and sometimes the federal government if the organization receives sufficient funds. Now, 54% of nonprofit organizations have an audit committee, which is an indication how important that can be. So nonprofits don't file tax returns, or at least that's something that a lot of people think. Do we? Well, obviously of a sort. Forms 990 are filed by most nonprofits unless they are really small. In fact, you have to file them, or if you don't for a period of 3 years, the organization loses its tax exemption with the IRS. And I don't know if you folks remember when that happened. I can't remember exactly what year this was instituted. It was 2010, somewhere around there. And at that point in time, literally, I think it was over 1 million organizations lost their tax exemption. Now, some of them may have been organizations which were no longer operating, but there were a lot of scrambling done by organizations to get their exemptions back. Now, again, filed by most nonprofits, the IRS recommends that the 990s be reviewed by the board prior to filing, a good way to know what's happening. They can be published on the internet as a public face to the organization, and they are required by the IRS to be made available upon request. So a question to you. Does your organization have the board review its Form 990? If you'll answer yes or no. All right, well, that's a pretty good number, 73.6% yes and 26.4% no. It's something I think that's happening more and more, and again, I think it's probably a good idea. So let's consider one last scenario. We've been in the paper lately and everyone is calling to ask for information. We aren't going to give them anything, it's none of their business. Well, can the organization do that? It's a question of whether it's a good idea from a policy standpoint, but legally there are limits. So with respect to transparency and accountability, which the IRS wants organizations to have, the IRS at least requires nonprofits to provide their exemption application, their Forms 990 for the previous 3 years, or Forms 990T. They can be published and available in that way, or the organization may have to make copies and give them to the individuals requesting. Organizations might also consider providing their bylaws, their conflict of interest policy, and even financial statements. The bylaws, for example, might be available already if their exemption application has them attached, and obviously individuals can get articles if they're available at the state level. So in considering the rules and best practices we've talked about up to now, I want to just give you some useful websites. BoardSource is a great organization, Better Business Bureau, Stay Exempt, IRS.gov, GuideStar, etc., all having information about helping organizations. But that's not the end of what we're here to talk about, because I'd like to leave you with some suggestions for optimum board performance. So these came from a 2017 survey done by BoardSource, and I think they have some good points to make. As I've said, board members should be public advocates for their mission. They need to go out there. They need to help the organization. But in order to do that, board members need a strong understanding of their organization's programs. And this brings about better engagement and better fundraising. And then boards that regularly assess their performance perform better on their responsibilities. So do those annual assessments by the board. An interesting one, boards that spend social time together work better as a collaborative team, which helps the board achieve its goals. How many boards do this? Maybe they do it on an informal basis, but it's something to consider for your organization. Have board job descriptions and perhaps even contracts where people agree that they're going to show up, that they're going to give money, that they're going to serve on committees. And then perhaps create a yearly work plan so the people on the board know what they're doing. So how do you make those board meetings better? How do you get people to attend? One way is to rotate which board members lead sections of the meeting. So it's not always the same voices, the same individuals you're hearing, but you're bringing in other people. Send out the agenda prior to the meeting so people know what they're talking about and are prepared to discuss. Give agenda items a time frame. It gives people some assurance that some subjects are not going to be given short shrift and others are going to take over. And move non-controversial items to a consent agenda. And again, that way you're not spending a lot of time talking about routine matters. Finally, collect RSVPs for meeting. No reason to meet if there's not going to be a quorum. Note off agenda items for later discussion. Use periodic self-assessments, as we talked about, and then document decisions. It protects the organization and the board, and also provides a history for those considering things. We're right at the end of our hour, so if you have questions, please send them. I will try to answer them in an email. Thank you for joining me today. I hope the information was helpful to you and your organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs. And again, this concludes our webinar, and thank you very much.